Mr. Wood, please call the roll.
Dennis Bridges. Here. Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm. Robert Shackelford.
Here.
Mr. President, you have a quorum. All board members are present.
Thank you, Mr. Wood. Need to review and adopt the meeting agenda.
Motion to approve the agenda as presented.
Second. We have a motion by Mr. Ross, second by Mr. McKinney. All in favor? Aye. Any opposed? Motion carries. Next, to review and approve the September the 10th, 2019 meeting minutes.
Make a motion we approve the minutes of September.
We have a motion by Mr. McKinney, and we do have a second by Mr. Bridges. All in favor?
Aye.
Any opposed? The motion carries to approve the September the 10th meeting minutes. We'll move on to the legal report. Ms. Pamela Spicer.
Good morning, everyone. Before we start, Mr. Duffer, if it's appropriate, I'd like to ask Shalina Brown to give us an update. She has an update on the, I believe she has a consent order to bring to your attention.
Ellis Bell consent order.
Good morning, board members. My name is Shalina Brown, and I am an attorney up in the legal department. And matter to handle the Bevis Bell matter. We entered into some negotiations to settle this matter and have come to a resolution, and I'm here before you to request the board's acceptance and approval of this revised consent order. The civil penalty has been reduced after much negotiation. This involves the unlicensed funeral directing. And as you may recall, the companion case to this matter was the Roland Gossi and Signature Funeral Homes by Premier matter. Presented, and you heard a few months back, it was presented by two other attorneys, Ashley Gino. So I request that you accept this consent order into set.
And it has been paid, correct?
Yes, they have submitted the civil penalties.
I'll make a motion that we accept this order.
We have a motion by Mr. McKinney to accept this order.
Second.
We have a second by Mr. Rahm. Is there any questions, gentlemen? All in favor?
Aye.
Any opposed? So the motion carries. We certainly appreciate your efforts.
Very much, I appreciate it.
We'll now proceed with the legal report. I'll allow Elizabeth Mendel to present the legal report. I'll be presenting the last complaint on the represents number 7. Other than that, she'll do 1 through 6.
Thank you.
Good morning, gentlemen. Turning to item number 1, it is complaint 2019-046 establishment. As you can see, they have some disciplinary history. This is complaint based off an inspection at the request of office staff because the new owner would not make an application for a change of ownership prescribed time. During the inspection, the representative discovered that the establishment had been notified but had failed to file a change of ownership application in a timely manner. They had also discovered that the establishment failed to file an application for a change of ownership within the prescribed time in the board rules. Subsequent to the issuance of the notice of violation, the respondent filed a change of ownership application with the board on June 30th, 2019. The respondent did not provide a response to the complaint. It's legal's recommendation at this time for an authorization for a formal hearing and to authorize settlement by consent order with a $500 civil penalty, $250 for the violation, and $250 for failure to respond to the complaint.
What was we know what the length of time was that they did not respond to the complaint, or did they ever respond to the complaint?
They have not responded at all to the complaint.
I'd like to see the failure to respond increased to $500. I can't imagine an establishment or a licensee not responding to this board, and I just don't feel like $250 is enough. So I'd like to see that portion increased to $500.
I would agree with that, Mr. McKinney. And do you want to put that in a motion?
Yes. Yeah, so it would be a total of $750, $250 for the violation, and $500 for failure to respond.
Second.
So we have a motion by Mr. McKinney, and we have a second by Mr. Ron. All in favor? Aye. Any opposed? Motion carries.
If I can interject, are we going to consider increasing the civil penalty for failure to respond to $500 for complaints?
Future cases?
Correct. Okay.
I would. I think when I say in the past, probably in my first lifetime on the board, I think probably we may have done some even more stiff than that. But I think 5 ought to be the minimum.
I totally agree with that. You want to put that in a motion?
Do you need that, or is that just for your information?
I'm asking because we have other complaints on this legal report where you're going to see the $250 civil penalty for failure to respond. That has been what we have submitted. So if we're going to consider increasing it to $5 for future violations for failure to respond, yes, it'd be great. A motion on that.
Well, I think the 500 needs to be the benchmark myself. Yeah.
So you want to make that a motion, Mr. McKinney?
If council thinks that's appropriate, yes, I will.
She just said that it would.
Yes.
Second.
So we have a motion by Mr. McKinney, and we do have a second by Mr. Rom. Is all in favor on this? Aye. Any opposed? So the motion carries.
Just to be clear, it is within this board's discretion to determine the civil penalties. Legal makes recommendations on the civil penalties. It's within your discretion to increase the civil penalty or decrease the civil penalty, issue a letter of warning, or close a complaint with no action. We obviously try to be consistent both in legal and as a board, as you all know. However, it is within your discretion to increase the civil penalty from whatever legal recommends, both increase or decrease. There is no policy on a civil penalty. Civil penalties are provided in the statute, and there is a range that you are given.
Well, that motion is more of a guideline, I guess, for your office?
Yes, the way I see this is that the board is directing legal in the future for failure to respond to a complaint that you would like to see a $500 civil penalty initiated. Obviously, these are always brought to the board for your review. If you determine at some point that you would rather the civil penalty be more or less, it's within your discretion.
Yes, ma'am. I understand if maybe the licensee is, or the manager is sick, or, there could be some circumstances where that maybe they fail to respond. But just, for no reason at all, not responding to the board, I think the action we've taken is appropriate.
Spicer, we appreciate that clarification. I think that all of us understood that piece, that each case is handled independently. We have had that similar situation discussed at the board meeting here, where that would be the beginning point of that particular type of issue or complaint, and how we would handle it as a guideline. So thank you. Any more questions or any comments, gentlemen? Okay.
So moving on to item number 2, it is complaint number 2019-046411, and it's against an establishment with some disciplinary history. Similar to item number 1, this is a complaint based on an inspection conducted by a board field representative at the request of office staff because the owner would not make an application for a change of ownership within the prescribed. During the inspection, the representative discovered that the establishment had been notified but had failed to file a change of ownership application in a timely manner, and that they had failed to file an application for a change of ownership within the prescribed time in the board rules. The respondent did respond to the complaint and indicated that they had filed a change of ownership application, and it appears at this time that the respondent has filed a change of ownership application. It's legal's recommendation at this time for authorization for a formal hearing and to authorize settlement by consent order with a $250 civil penalty.
Motion to approve the recommendation.
Motion by Mr. Rom. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries.
I'm assuming you're sensing a pattern, but complaint number 2019-046421 against a funeral establishment is also a complaint based on an inspection where the respondent establishment did not complete an ownership application within the prescribed time. During the inspection, the representative for the board discovered the following: that the establishment had been notified but had failed to file a change of ownership application in a timely manner, and that the establishment failed to file an application for a change of ownership within the prescribed time in the board's rules. At this time, the respondent has not responded at all, and per our previous discussion, it's legal's recommendation to authorize for a formal hearing and authorize settlement by consent order with $500 civil penalty, or $750 civil penalty, $250 for the violation, and $500 for failure to respond to the complaint. I'd also note that they have since filed a change of ownership application with the board.
Motion to approve.
We have a motion by Mr. McKinney. Is there a second?
Second.
We have a second by Mr. Shackelford. All in favor? Aye. Aye. Any opposed? Motion carries.
Item number 4 is complaint number 2019-046441. It is against a funeral establishment with some disciplinary history. This is, again, an inspection performed at the request of office staff because the owner did not make an application for a change of ownership within the prescribed time. The representative discovered that the establishment had been notified but had failed to file a change of ownership application in a timely manner or within the prescribed time in the board's rules. They have also not responded to the complaint at this time. They have since filed a change of ownership application with the board in July of 2019. It's legal's recommendation to authorize for a formal hearing and authorize settlement by consent order with a $750 civil penalty, $250 for the violation, and $500 for failure to respond to the complaint.
Motion to approve?
We have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Davis. All in favor? Aye. Any opposed? Motion carries.
Item number 5 is complaint 2019-048051 against a funeral establishment. This is a consumer complaint alleging that the respondent's employee treated the deceased family unfairly compared to the treatment of the deceased estranged wife. The complaint was filed by the deceased sister. She states that the respondent's chief of operations knowingly misrepresented information regarding the costs of funeral and burial services. She alleges that a higher fare was provided to her and her sister that was provided to the deceased estranged wife. She alleges that the respondent neglected to disclose information about the expenses associated with the burial arrangements, leaving her with an additional bill of $1,800. She further alleges that the respondent failed to provide a copy of the death certificate to the deceased family. The respondent did respond to the allegations, and they indicated that they were unaware of any mishandling or concerns the family had, that their funeral arrangements were split evenly between two insurance beneficiaries, one being the deceased wife's and the other being the sister's, and that the burial arrangements were made by a completely different entity, not made by the respondent, and they were not aware of any charges. Lastly, they stated that there was one death certificate itemized on the bill when the arrangements were made, and the respondent will order an additional copy to provide to the consumer. The respondent also provided a copy of the funeral bill and the insurance assignments signed by all of the parties. The provided documents show that the funeral costs were split evenly between the sister and the deceased wife. It's legal's recommendation to close this at this time.
We have a motion on the table by Mr. Rahm. Do we have a second? We have a second by Mr. Davis. All in favor? Aye. Any opposed? Motion carries.
Item number 6 is complaint number 2019-048591 against a funeral establishment. This is an inspection conducted by a board field representative at the request of office staff because the new owner did not file an application for a change of ownership within the prescribed time. The representative discovered during the inspection that the establishment had been notified but had failed to file a change of ownership application in a timely manner or within the prescribed time in the board's rules. The respondent has not responded at this time. They have since filed a change of ownership application with the board in June of 2019. It's legal's recommendation at this time for authorization for a formal hearing and to authorize settlement by consent order with a $750 civil penalty, $250 for the violation, and $500 for failure to respond to the complaint.
We have a motion.
Motion to approve.
We have a motion by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Bridges. All in favor? Aye. Any opposed? Motion carries.
On the represents, gentlemen, we have number 7, which is 2019-045801. I presented this to you all at the September 2019 board meeting, just by way of summary and to refresh your memory. This is a consumer complaint. The deceased family filed the complaint. I have spoken to this individual. There seems to be confusion because of the length of time that had been, I guess, between the length of time between the time the contract was entered into with the complainant's parents and the date of death. But the remaining issue that you all asked me to look into at the last board meeting was concerning the vault. We reached out to this respondent, and as of yesterday, I received a response confirming that, in fact, one family member was buried without a vault. They have refunded this money. There appears there was a problem with the paperwork. Some of the paperwork had been misplaced. The family had asked that the deceased be buried in a different location. So there seems to be some confusion, not making excuses for anyone involved. but I'm just letting you know the facts as they were presented to me. So those are the facts as we have them. We have the deceased buried without a vault that had been paid for. Apparently, the letter confirming that the vault would be provided was missing, and then was provided for by the family. That money has now been refunded, and that's where we are today. Initially, you all had decided on a $250 civil penalty for failure to respond. I would agree that a $500 penalty for that would be appropriate based on the fact that it took legal having to call and email to get a response. Now we have a response, and then I would defer to you all on what, if anything, else would be appropriate other than the $500 civil penalty for failure to respond.
Questions, gentlemen?
So I take it, that even though the family has been refunded the money for the vault that they should have gotten, that they're still disturbed because their loved one did not get what they had bought and paid for?
Correct.
Okay. I feel like it ought to be at least $500 for the non-response and at least $500 for the mess up in not providing the merchandise that they should have, even though they have refunded the family. If it was my family, I'd make them take them up and put them in it. But anyway, that's how I feel.
And from speaking to this consumer, that is not her intent. I understand your position, but just so you know, that's not her intent. But she did feel like it was important to file this complaint and bring it to the board's attention.
Yes.
Hey, Ms. Bosser, refresh my memory on exactly why the vault was not provided. They went to another cemetery, you said?
The deceased was buried in a different cemetery. However, there is a letter that was provided by the consumer that states that the vault had been paid for. Apparently, there was some confusion about whether the vault had been paid for or not. And it has since been discovered that the vault was paid for, but for whatever reason, they did not provide the vault.
So the same establishment had the funeral, and they buried the decedent in another cemetery? Is that what I'm hearing?
Correct.
Was the vault paid for through the funeral home or through the initial cemetery where the burial was to be conducted?
Based on the paperwork that I have, it appears that it was through the funeral home. They decided on a different cemetery, but this was decided upon not by this consumer, in other words. The deceased family didn't make the decision to bury the loved one in a different cemetery. It's my understanding from reading the materials and the letter that was provided that this provision was put in place by the now deceased.
I don't, y'all have to catch me up, I guess, but I don't understand what difference it made what cemetery it was going in. If they bought the vault from the funeral home, they should have provided it. Doesn't matter where it was buried. Sounds like either a mix-up or poor record keeping or whatever, but I just think there should be some penalty other than them just, paying the family back in order to get their attention that hopefully this never happens again.
I certainly would agree that the facts should have been decided on, and the vault, whether they had a vault or not, should have been decided before the decedent was buried, no matter what cemetery.
And to help clarify, it is my understanding this letter that is being referred to was provided because the deceased had decided to be buried in a different cemetery. So there was a letter provided that specifically stated the vault, opening, closing, all of this would be provided for in a different cemetery. Then, when, let's say there were two individuals deceased, when the second individual passed, that letter could not be located at the time that individual was buried without a vault. The respondent specifically states that the letter stating that the cemetery would provide the vault is not in the file. The funeral director did not remember seeing the letter, and we believe it was provided by the consumer at a later date, without giving names, obviously.
Which they should have had that documentation in the file.
Correct.
Mr. McKinney, is it your recommendation or your motion that the fine be $1,000, $500 for each? Is that correct?
Yes, if the rest of you think that that's suitable, or you want more or less, but I definitely think that needs to be the floor.
Willing to put that in form of a motion?
Yes, sir.
So we have a motion by Mr. McKinney with
Second.
$500 each.
Yes.
Okay, and then we have a second by Mr. Rom. All in favor? Aye. Any opposed? Opposed. We have an opposed by Mr. Davis on record. So the motion carries.
And just to be clear, for number 7, you all are recommending I've recommended authorized formal hearing, and the initial recommendation was $250 civil penalty for failure to respond. Based on my update, the new board decision is authorized formal hearing, $500 for failure to respond, and $500 for failure to provide the merchandise that had previously been purchased.
Yes.
Thank you.
Thank you, Ms. Spicer. Thank you, Ms. Bendale. And welcome to the board representing all of us in this. Moving on to the director's report.
Mr. President and board members, the first thing is a legislative update. Our office has not received any official notification from either the Tennessee State Funeral Director and Morticians Association or Tennessee Funeral Directors legislation that they intend to pursue during the upcoming legislative session. We extend an invitation to both associations and any other interested parties to meet with the office staff and legal prior to introduction of legislation affecting the Board of Funeral Directors and Embalmers. The licensee report is a report of licenses administratively approved by the Executive Director pursuant to Board authority for the period of September 10, 2019 through October 7, 2019, and you have a list of individuals there that were approved for various types of funeral director and embalmer license, either by reciprocity. Closed establishment report. We have one establishment that's reported closing since the last board meeting. That's McEwing Funeral Home, 31 Indian Creek Road in McEwing, Tennessee. And the complaint report for today, as of yesterday, there were 12 complaints against funeral directors and or embalmers in 20 establishments for a total of 35 complaints. I do expect that the next board meeting will have some financial information for you for the fiscal year that ended June the 30th. That was not completely available today, so we wanted to get it finalized, and the Assistant Commissioner's Office will give us some information. We'll have it for you, we expect, by the next board meeting. Be glad to answer any questions you have.
Questions, gentlemen?
I move that we accept the director's report.
We have a motion to accept the director's report by Mr. McKinney. Do we have a second?
Second.
We have a second by Mr. Mr. Davis. All in favor? Aye. Any opposed? Moving to the license applications.
Mr. President, there are no individuals nor are there any establishments to appear before the board today for consideration of approval.
Any new business? Do we have a motion to adjourn?
So move.
Motion by Mr. McKinney. We have a second by Mr. Bridges. Thank you, gentlemen.
Well, I wouldn't. We've had a few of those here lately.